Before this hearing even begins, you need to understand something important. This isn't just another routine courtroom case. This is the story of a young man who was already given multiple chances by the justice system, and somehow still ended up right back in the same courtroom, facing an even bigger consequence. Kevin Ross isn't here for a simple mistake. According to the court record, he was already on probation for evading arrest with a vehicle, a serious felony offense. But just months later, he allegedly did it again, and this time the situation escalated into a high-speed chase that reportedly reached speeds of over 120 miles per hour. Now think about that for a second. When someone is already on probation, the court expects them to stay out of trouble completely. Even a minor violation can send them back to prison. But in this case, prosecutors say Ross didn't just violate probation, he repeated the exact same dangerous behavior that put him in trouble in the first place. So the judge sitting here today has a huge decision to make. Should Ross get yet another chance, or is this the moment where the court decides enough is enough? As this hearing unfolds, pay close attention to the evidence, the explanations, and the judge's reaction, because by the end of this video, Kevin Ross's future will be decided inside this courtroom.
Kevin Ross.
Yes, ma'am.
And Mr. Ross was previously in court, entered a plea of guilty in a new offense in clause number 25 DCCR 1310 to evading arrest or detention with the use of a vehicle. And then in clause numbers 24 DCCR 1198 and 1199, there were motions to revoke probation, and he entered pleas of true. And let me go figure out which. Evading arrest or detention with the use of a vehicle, and then also the evading arrest, the misdemeanor, from June 13th. He pled true to both of those. Pled not true to a possession of a marijuana case, not true to possessing marijuana, not true to never becoming intoxicated, regarding a drug patch, positive for cocaine, and then pled true to 6, which was that he was out past curfew at 1:39 a.m. on June 13th, and also that he's behind in his court assessed fees. And those were all the same in those motion to revoke cases. One, he's on probation for evading arrest or detention with the use of a vehicle, and these were 4-year deferred probations from December 18th of 2024. And the second one was deadly weapon in a penal institution. So all three of these are third degree.
At this point in the hearing, the judge is laying out the legal foundation of the case, and it's actually more complicated than it might sound at first. Kevin Ross isn't dealing with just one charge here. The court is reviewing 3 separate legal matters at the same time, 2 motions to revoke probation, and 1 brand new felony case. A motion to revoke probation basically means the court believes someone violated the conditions they were given when they avoided prison the first time. When probation is revoked, the judge can immediately impose the original prison sentence that was previously suspended. In Ross's situation, these are third-degree felonies, which in Texas can carry sentences of up to 10 years. But because of the specific agreements and caps involved in this case, the maximum punishment the judge is considering here is 8 years. And here's why this is such a critical moment. When someone stands before a judge on a probation violation, the court isn't just deciding whether they broke a rule. The judge is evaluating whether that person can be trusted with freedom again. That's a big question, and the testimony we're about to hear from the probation officer will play a major role in shaping that decision.
So all 3 of these are third-degree felonies. We've got 2 motion to revokes, 1 new case, cap of 8 years on all of them. I'm sorry. Would you please raise your right hand? That's who did the PSI. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
Police court, for the record, could you state your name, please?
Letting know, bro.
Speak
And
up,
ma'am,
please, ma'am.
Letting know, bro.
Thank you.
And you're the probation officer for Mr. Ross?
Yeah.
How long have you been his probation officer?
Not long at all. I think I got, I'd only been seeing him 2 months since the admin hearings.
Okay, and so 2 months from today, back?
Yes.
Okay. And have you gone out to see him or talked to him?
Yes.
And when you went up to talk to him, what were your impressions of him? I know he was in jail. Was he respectful?
Yes. He was respectful.
Okay. And you know that the court now has to decide whether or not to send him to TDC or to continue him on probation. Right? You understand too that he was on probation for evading with a motor vehicle, and approximately 6 months, 5 months later, he's arrested for the same offense. Did you have a chance to take a look at the probation report? Right. Yeah. And what I want to get to real quickly is that the person who did this report, that wasn't you, right? Or was it?
The report?
Yes.
The hearing?
No, the report. PSI report.
No, sir.
Okay. It says here that he exhibits strengths, but he also has some concerns. Is that how you view it also?
Yes, sir.
Okay, can you explain a little bit about what his strengths are that you've seen? Very briefly.
So dealing with probation, he's pretty mild mannered than me. He acts respectful, but in the real world, I feel like he has some issues.
Now
And
listen
what issues?
carefully to what the probation officer is saying here, because her testimony is extremely important. She describes Ross as respectful during their interactions, which on the surface might sound like a positive sign. But then she quickly adds something that raises concerns. She believes Ross struggles with anger and may not fully understand the seriousness of his legal situation. That kind of observation can carry a lot of weight in court. Judges rely heavily on probation officers to evaluate whether someone is capable of successfully completing supervision. If an officer believes a defendant doesn't fully grasp the consequences of their actions, it suggests the same mistakes could happen again. She also mentions that Ross may have certain disabilities that could affect his judgment. That's another important factor, because courts sometimes consider mental health or cognitive limitations when deciding whether someone should receive treatment programs instead of prison time. But there's a problem here. The officer explains that everything happened too quickly after Ross was placed on probation. The new offense occurred before any rehabilitation programs even had time to work, and that leaves the judge with a difficult question. Was Ross given enough time to change, or did he already prove he can't follow the rules?
Okay, and what issues would that be?
Anger. And I feel like he's confused. Like most of the time when we're in probation, he calls his mom, and I don't feel like he can really understand the gravity of probation.
Do you take that because of his age, or do you think that he's just defiant?
I don't think it's age, or it could be a mix of both. But
Okay, how about did he have any learning disabilities that you remember that could also affect his judgment?
I think he's on disabilities.
Okay, and what would he be on disability for, from your understanding?
I think it was a lack of disabilities.
Knowing all that, could that be one of the causes for the way he's acting?
Yes, it could play a part.
Was he ever given the opportunity to go into any of the probation programs that could be possible to address these issues?
They're doing things happening too quick.
In order to allow him to see if you can't straighten him out. But he was reporting
Yes.
and doing all the other things, but the new offense happened too quick before
You can really work probation.
anything at all. Are there programs out there or in-house or outpatient programs that could be available to them?
Not that I can recall right now.
There's nothing that they can do like a ISF or some type of program to say, hey, let me try to straighten you out, give you some skills, give you some opportunities one last time.
maybe ISF or like cognitive.
I mean, in-house, it has to be something that's what you're running.
Yes.
I have nothing further to do.
Thank you.
Just a couple questions.
Sure.
Ms. Malbrough, as Mr. Roth's probation officer, whether you were in direct supervision of him or taking over the file from another officer, have you had an opportunity to review the entirety of his file? And do you
I
know,
need you to speak
Yes,
up,
ma'am.
please.
and do you know that when the new offense occurred and which he has pled true to on June 13th of 2025, was he wearing a drug patch at the time?
Yes, ma'am.
And based on your review of those records, do you find that the drug patch at that time on that date showed that it tested positive for
Things
cocaine?
start to look even more serious when the prosecutor begins asking about the drug patch results. For those unfamiliar, a drug patch is a monitoring device placed on someone who is on probation. It continuously tests for drug use over a period of time. If the patch comes back positive, it becomes strong evidence that the person violated the terms of their probation. According to the testimony here, Ross's drug patch reportedly tested positive for cocaine at the time of the new incident. If that's accurate, it would count as an additional probation violation on top of the new evading arrest charge. But the prosecutor doesn't stop there. She also references the high-speed chase itself, describing it as extremely dangerous. This is where the stakes really start rising. Courts take evading arrest with a vehicle very seriously because it puts not only police officers at risk, but also innocent drivers and pedestrians. High-speed pursuits can easily turn deadly in seconds. So now the judge isn't just evaluating a technical violation. The court is looking at a pattern of behavior that suggests escalating risk. And that's exactly the kind of situation where judges begin to question whether probation is still the right option.
Positive for cocaine.
Yes.
And would that have also been an additional violation of his probation?
Yes, ma'am.
And is that also an issue that was trying to be addressed both with the drug patch and with the underlying original probation?
Yes.
Do you also know or happen to know that the officer involved in the courtroom recall from the new evading has now been relocated to Dallas for the courtroom recall, the video that you had reviewed previously? Have you had an opportunity to briefly review those offense materials? And you know that to be a very egregious high-speed evading through all parts of Jefferson County.
Yes, ma'am.
And would it be your recommendation to continue Mr. Ross on any kind of probation at this time, or he can be revoked by the court?
Like this.
Any other questions of this witness?
Witness, Judge.
Any other witnesses?
Just Mr. Ross.
Mr. Ross, raise your right hand the best you can. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go
I
ahead.
please the court, just for the record, state your name.
Kevin Roth.
And Kevin, state, the court needs to now decide what to do with you, right?
Yes,
Simple
sir.
terms. Send you to the penitentiary or possibly give you a second chance. What would you like this court to consider?
Give me a second.
Now we finally hear directly from Kevin Ross himself, and this is often the most emotional moment in hearings like this. When the judge asks what the court should do, Ross immediately asks for another chance. That's not unusual. Defendants almost always hope the judge will give them one more opportunity instead of sending them to prison. Ross tells the court that he has 3 jobs lined up once he gets out, which is a common argument used to show the judge that someone plans to turn their life around. Stable employment can be a strong factor in favor of probation because it suggests structure and responsibility. But the judge isn't just looking for promises. The court wants proof that someone has actually learned from past mistakes, and that's where the judge starts pressing him with tougher questions. Why would someone who was already given a second chance decide to run from police again? That question cuts right to the heart of the case. Because if Ross can't provide a convincing explanation, the judge may see this not as a one-time lapse in judgment, but as a pattern of reckless decisions.
Give me a second, Sean.
Okay, well, what do you base that on?
Like ISF.
Okay, but what do you base that on? What good do you have to say that I possibly will succeed?
Got a job. When I get out, I got a job, 3 jobs lined up for when I get out.
You have a place to stay.
Got a house.
You have 2 parents that are very disappointed in you, but they're still supportive, correct?
Yes, sir.
One of them actually works for a prison system, don't they? Mom,
Yes, sir.
she knows what happens in there.
Yes, sir.
And has she ever indicated to you that you're not penitentiary material? That
Yes, sir.
is that it's not a good place for you.
Yes, sir.
Well, tell me why, once this court gave you a second chance, that you decided that you wanted to go and get in a car and try to evade a DPS officer.
You can say it again.
Why did you make that decision after this court gave you a second chance to get behind the wheel of a car and try to, I guess, get away from a DPS officer? Why didn't you stop?
It was like I was I was the wrong place, wrong time, and I was.
Did you really think you could?
How were you, hold
Oh,
on.
sorry.
Huh?
Think about your answers very carefully. What does being at the wrong place at the wrong time have to do with this insane chase that you went on?
This is where
Insane.
the
I mean,
tone of the courtroom starts to shift dramatically. When Ross tries to explain that he was simply in the wrong place at the wrong time, the judge immediately pushes back, and you can hear the skepticism in the judge's voice. From the court's perspective, a high-speed chase reaching 127 miles per hour is not something that just happens accidentally. That's an intentional decision that puts lives at risk. The judge also highlights something that many viewers might be thinking: blaming the situation on the wrong crowd doesn't erase the fact that Ross was the one driving the car. In the eyes of the law, responsibility doesn't disappear just because someone else was involved. And this moment reveals a key turning point in the hearing. The judge isn't just evaluating Ross's past behavior anymore. The judge is evaluating his credibility right now. Does his explanation sound sincere? Does he truly understand how serious this situation is? Those impressions can influence a sentencing decision more than people realize. So the big question now becomes: has Ross convinced the court he deserves another chance, or has he just made things worse?
insane. I mean, 127 miles an hour crazy. What does that have to do with being at the
I
wrong
was
place?
with the wrong crowd at the wrong time. Like,
So the people in your car were the wrong crowd?
yeah, like I was just hanging with the wrong people.
And that's what made you run from the
When I
car?
stopped, they just were like, nah.
Okay.
It was just intense. Like, I stopped for them and they looked at me and was like, nah. Don't. It just,
Because y'all were doing stuff you shouldn't have been doing in the car. Right?
no, man.
No?
I was coming from the house going to get something to eat.
Okay. Go ahead.
Are you asking this court to consider giving you a second chance at putting in you some type of program?
Yes, sir.
Is there anything else you'd like to tell the court?
Like how she brought up the write-ups. I just was.
I'm gonna address that. Let's bring up the write-ups.
Right here,
Yeah,
the hearing takes an interesting turn. Instead of focusing only on the high-speed chase, the court begins examining Ross's behavior while he was already in custody. The judge mentions that Ross has 15 pages of disciplinary write-ups from the jail. That's a huge amount. For anyone who doesn't know, behavior in jail actually matters a lot during sentencing. Judges often review jail incident reports because they provide insight into how someone behaves when they're already under strict supervision. If someone continues breaking rules even inside jail, it can signal that probation outside jail may not work either. Ross tries to defend himself by saying many of those write-ups were misunderstandings or situations where he was simply around other inmates who were gambling or causing problems, but the judge clearly seems concerned. The court isn't just looking at one mistake anymore. It's looking at a pattern of rule-breaking behavior, both outside and inside the system. And that pattern is starting to paint a troubling picture for the judge.
Bring up the write-ups. You have 15 pages of write-ups. Why? Oh, there's another one. It's just on the,
One's yours, one's Ashley's.
Like the last few rounds, like I defend, it was just defending myself.
The last write-up you got is because you were urinating on something outside at the jail. Am I wrong? Am I reading that wrong?
You must have got the wrong person.
said you were urinating by a door by the rec yard on Hillside.
When this was,
Then walked
March
down the
10th.
sidewalk, observed you, in
It's
fact.
today. That's today.
What's
today?
they must have got the wrong person.
So this morning at 6:40 this morning,
Yeah, they got the wrong person. I came out of the dome at 7 o'clock, 7:02 on the dot. They woke me up late. She must have got whoever wrote it got the wrong person.
I'm gonna check on that. Go ahead though.
I just have comment in reference to the write-ups, Judge. I have no further questions of this class.
All right, any questions? The
No.
witness?
Now the defense
Right, go-
attorney steps in to provide some context for those jail incidents. His argument is actually something courts hear quite often. Jails can be chaotic environments. When you place dozens of people together in one dorm area, many of whom are already facing criminal charges, conflict and rule violations tend to happen. The defense essentially argues that some of Ross's write-ups may simply be the result of living in that environment. Gambling, arguments, and minor conflicts can occur when people are crowded together with little to do. The attorney isn't saying Ross behaved perfectly, but he's asking the judge to consider the conditions of the jail environment before using those reports too heavily against him. However, this strategy carries risk. While judges understand that jail can be difficult, they also expect inmates to follow the rules regardless of the environment. And the prosecutor is about to argue that Ross has already received more opportunities than most defendants
The witness.
ever get.
Right, go ahead.
Reference to the write-ups, Judge. I understand that there's a problem in jail. And I know the court is well aware of what's been going on there like this and talking abusively to the jailers, gambling, fighting. But I'd just like to, I know the court realizes that when you put 30 or 40 people that are accused of crimes, they're not the best people probably in the world, and you put them all in a dorm and ask them just to sit there and not do anything, there's going to be problems. There's gambling, just like people gamble at their house, people do other things. I know that they're told not to. I know it's against the rules. Being disrespectful should not happen. I'm not here to tell you that. Fighting, I think that's probably a cause of everybody on top of each other, everybody living together in dorms. And it's just a fact of wherever you go, families fight between themselves. They fight. Now, is it right? No. He's in custody. He has to now come in front of this court and say, please give me probation, when you have to consider jail time and his actions in jail. And I know the court is well aware that it's a difficult situation for people, especially the type of people that are incarcerated, to all get along and be friendly and sing songs together. I'm not trying to be funny, Judge. So I would ask that you take that in consideration once the incident reports. Calling the jailers names, being disrespectful, There is no need for that, and I would tell you that he is wrong, and he apologized for that when I talked to him, to the officer. But that's my comment on these jail things, Judge.
Ms. Malvina?
Here's where the
Judge, I don't-
prosecution makes its strongest argument. The prosecutor reminds the court that this wasn't Ross's second chance, it was actually closer to his third or even fourth opportunity to straighten things out. That statement hits hard, because the criminal justice system often gives defendants multiple chances before imposing serious prison time. According to the prosecutor, Ross had probation opportunities in the past and still continued engaging in dangerous behavior. The high-speed chase alone could have ended in tragedy. Driving over 100 miles per hour during a police pursuit puts not only officers at risk, but also innocent people who happen to be on the road. The prosecutor is basically telling the judge, at some point, chances run out. The argument being made is that Ross has repeatedly ignored the warnings given to him by the court. And if that's true, the prosecution believes the only appropriate sentence now is the maximum punishment allowed under the agreement, 8 years in
Ms.
prison.
Malvina? Judge, I don't really feel the need to tell the court anything that you probably, I know you already know. This wasn't his second chance. This was his third chance. Now he's asking for about a fourth chance. He squandered those opportunities, and then while awaiting your sentence, he cannot behave. I don't think that there's any reason to sentence him to anything less than the 8 years. The court's previously rejected a 5-year offer, and I think obviously that was a wise decision, and I asked for 8 on all of it.
Judge, there's no excuse for what he did. It could have turned out very bad, doing 100+ miles an hour. Thank God it was at night with not much traffic, because it could have, or he could have lost control of the car. He does have some
He
mental
did,
health.
he crashed.
No, he didn't crash.
Crashed out at 2225 Salisbury.
I saw it
Drive.
parked in front of the house. He actually ran into the house.
And climbed up into the ceiling and had to be brought down at
Right,
gunpoint.
He didn't crash. He drove home.
Okay. Mr. Ross, so what I'm looking at over here and reminding myself of, just because it's been a little bit, is several things. One,
Now the judge begins walking through Ross's history step by step, and this moment is incredibly important. Judges often do this out loud so the defendant and everyone in the courtroom understands exactly why the final decision is being made. The judge reminds Ross that the original offense involved evading police with a vehicle and crashing while armed with a gun. That alone is already a serious felony. But then the judge points out something even more troubling. Only about 5 months after receiving probation, Ross was involved in another high-speed chase. And this second incident appears even more dangerous. According to the court record, the chase involved multiple law enforcement agencies, extremely high speeds, lights being turned off, and a vehicle filled with other passengers, including a juvenile. There was also reportedly marijuana and a firearm inside the car. When judges review cases like this, they look for patterns. And from the judge's perspective here, the pattern seems clear. Repeated risky behavior, repeated encounters with law enforcement, and repeated violations of probation.
several things. One, the underlying offense that you were placed on probation for in the first place, the evading arrest or detention with
Yeah.
use of a vehicle, where you ran from the cops in a car, you did crash, and that's one. I think with another vehicle, but anyway, you had a gun on you. And so then you get probation, and not, 5 months later, something like that, you're out while you're on probation at almost 1 o'clock in the morning in a car with 3 other people. One's a juvenile. There's marijuana in the car. There's an AR pistol in the car. And you run starting at 9th Street and 9th Avenue and 41st Street and end up with DPS, Jefferson County, Port Arthur, Groves, and Nederland all having to be involved in a high-speed chase that went, you were blacking out, you're turning your lights off. I mean, it's just crazy. You're already on probation for the same thing. And then you do it and you do it really bigger this time with a gun, hanging out with the wrong people. You are the wrong person, right? You can't say that you're hanging around with the wrong people when you keep being a part of that. It's not their fault. You were driving. You were out with them with marijuana and guns doing who knows what. Then you get in our jail and act like an idiot in our jail. And I don't agree with Mr. Burbank that just because you're in jail and it's a difficult situation, that there should be some kudos given because there's a bunch of guys living together and you can't get along. You are getting along. You're gambling. You are getting, I mean, it's just the disrespect, the not following the rules just shows you got your opportunity on probation, chance one. You've already had an unlawful carrying a weapon misdemeanor that you were given 6 months deferred probation for. You've already had a resisting arrest back in 23 that you got a probation for. A possession of a dangerous drug, you got a probation for. That one's pending now, a motion to revoke. So you've been given those opportunities. Then you get an opportunity on a felony, 2 felonies, and now you've got another felony. So continuing probation, it's not.
I can make an announcement.
Can you make a comment?
No, hold on just a second. Okay. So, I've just received verification of the incident this morning from the supervisor that they're saying that it was in fact Mr. Ross who was written up this morning for the infraction that I already talked about. All right, Mr. Ross.
This exchange becomes one of the most revealing moments of the entire hearing. Ross continues trying to explain the jail write-ups by saying he was simply around other inmates who were gambling or involved in rule violations. But the judge quickly points out a key issue. If someone repeatedly gets written up for being around trouble, eventually the responsibility falls on them to avoid those situations. The judge's point is simple but powerful. Whether it's being in a car with the wrong people during a police chase or sitting near inmates who are breaking rules in jail, Ross keeps describing himself as someone who just happens to be in the wrong place at the wrong time. But the court seems to believe those situations are actually the result of his own decisions. This moment highlights a deeper issue judges often consider during sentencing: accountability. Courts want to hear defendants take responsibility for their actions. When explanations sound like excuses, it can significantly weaken a defendant's request for leniency.
What do you want to say?
About the write-up situation that you just said. The write-up that I get in the jailhouse, it don't be because I gamble. Like they play stuff at the table, and I'm just at the table watching.
Right. Like
everybody just get wrote up. We in the day room. It's the day room.
Right.
So everybody that's in the day room watching.
Like you were in the car and you're just around all the bad people. It's always somebody else's.
Then the disrespect, every write-up they write, they put disrespect stuff. You only got to say nothing. Like when I try to plead with the write-ups with the gambling, I plead to them. Like, look, it wasn't me gambling. They agree to it, and then they still put it in the system. Once it's in the system, they can't take it out.
So when they put a write-up that you're disrespectful, they don't just put the word disrespectful. They put the specific stuff that was said.
Yeah.
Yeah.
So when we got wrote up, I go to the desk, tell them like, look, that wasn't me gambling.
And you said it like that, really respectful, like you're talking to me. That's how you talk.
I said, that wasn't me gambling. They like, nah, we're not trying to hit it. You was in the group watching, so you're getting wrote up with them. But we in the day room together.
Okay.
The disrespect, the wrote up that you write up that you read to me last time when he said I called him a B word.
Mhm.
The lieutenant verified, ran the camera back and saw that I didn't tell him that
Okay.
and dismissed the write up.
Okay. So if you keep getting in trouble for sitting around watching other people gamble, and it doesn't happen just one time, but you keep getting written up for it, at what point do you learn to go sit somewhere else?
When it's the day room, we 50 deep in the day room. We're watching TV, getting on the phone.
Not everybody that comes in front of me is getting in trouble for gambling. There's somewhere else to go to not get yourself in trouble when you're looking at going to prison.
Try to sit on my bunk, fights come.
Okay.
I would
All right. At this
Oh,
time,
that's the way.
Mr.
And
Ross,
just
and
like
cause
that, the moment of decision arrives. After reviewing the evidence, the probation violations, and Ross's criminal history, the judge delivers the final sentence. Kevin Ross is found guilty and sentenced to 7 years in the Texas Department of Criminal Justice. The same 7-year sentence is applied across the related cases, and the judge orders them to run concurrently, meaning Ross will serve them at the same time rather than one after another. The judge also reminds Ross that because of this conviction, he will now be legally prohibited from possessing firearms or ammunition under Texas law. Violating that restriction in the future could lead to even more criminal charges. This case is a powerful example of how probation works in the justice system. Probation is meant to give someone an opportunity to avoid prison and rebuild their life. But when repeated violations occur, especially dangerous ones like high-speed chases, courts often conclude that incarceration is necessary to protect the public and enforce accountability. What do you think about the judge's decision in this case? Was 7 years the right call, or should Ross have been given one more chance to turn his life around? If you found this courtroom breakdown interesting, make sure to hit the like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom stories and legal breakdowns
at
just
this
like
time,
this.
Mr. Ross, and cause numbers, and excuse me, cause number 25 DCCR 1310, which is the new case. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1198, find sufficient evidence to find counts. Sorry, get back to that.
One, two, 6, and 7, Your Honor. And
Counts 1, 2, 6, and 7. You entered those pleas freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. And sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24 DCCR 1199, also find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a deadly weapon in an institution, penal institution. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I've handed you the trial court certifications. This shows that these were agreements I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. Good luck to you, sir. You can go back with the bailiff.